It's been quite a week on the premier current affairs show on radio, Deep Dive on Capitalk 100.4 FM with Rumbidzai Venge.
But the one thing that we cannot stop doing is conceptualizing, is thinking, is growing, and even sitting down and doing nothing is something. Somebody said that to me once.
The Deep Dive with Rumbidzai Venge, Monday to Thursday, 6 to 9 p.m. The premier current affairs show on radio.
Now welcoming my guest in the studio. Kuda, good evening. How are you doing?
Good evening, Rumbi. How are you? And good evening, listeners.
I'm fantastic. Hey, how was the traffic on the way in?
Yeah, it's frustrating. The congestion is just too much. Yeah.
But you know, I think it's okay. I think we need to suffer with promise. Because our roads are going to be looking and driving very nicely soon. So I think it's just the process that we've got to go through. Notification.
Exactly. We used to have that whereby a day or so before you would be notified in the press, even through social media, that such and such a road is going to be closed for some construction work or whatever. And then you would know that I have to avoid that route.
I guess we have to fill in the gap, but nonetheless, welcome. I'm glad you braved the traffic jungle and that you are here this evening. So this evening, we want to talk about deceased estates. We want to focus on the distribution of property and asset upon one's death. So this is often a very, very contentious one. So let's start from the two scenarios. I mean, what happens when someone dies? Let's call this, person A, Ben, and Steve. If Ben dies without a will, and Steve has a will that stipulates how he wants his property to be distributed, what happens to Ben's assets when he dies?
Okay, so when Ben dies, he doesn't have a valid will. The most important word there being a valid will. We have problems with people who be thinking all their lives that ndakanyora will, I have my will, but the most important question is it valid? Because sometimes we have those scenarios where after the person have deceased, we would then have those wills being declared invalid. And then it's another problem where we have to treat the estate as if there was no will at all. Then people also have got this problem of writing their will and they give it to whoever. If it's contested, it's as good as there is no will because it was never registered from the word go. So that's probably one of the most important things that people need to know. You need to get your will registered, properly drafted and registered. Then you know I'm good. Then if one dies without a valid will, without having written any will, or for some reasons which I've explained, then it's declared that there is no will. We have to deal with the estate, or by estate we are talking about the assets and liabilities of a person. They have to be distributed. In other words, the word distribution ya chirungu chinogona kusanzwisiswa newamwe, but what we are simply saying is, how are their assets supposed to be governed? Who is entitled to get what when the person is no longer there? So there is a legal process that has to take place. So if a person dies and they don't have a valid will, we have to go through what we call estate registration process. If the person was, to give as an example, maybe we say, angane mchato, all right?
Okay, hang on. Let's take a few steps back. Okay, let's talk about how to write a valid will. What constitutes a valid will? Nambonzo chitaroti unogona kufunga kuti iwewe your will is valid, but then for all you know it's not, and it will be challenged and set aside. So just give us very quickly what makes a valid will.
Okay, on that one, the most important information that I can give to listeners is that a will is a legal document. it's best you leave legal work to the experts. Get a lawyer to draft your will. That's the best way of doing it. Because uriwega, you will not be aware of some of these things which may make your will not to be valid. So I can give just some instances whereby what we are saying is the will have to be written while at least you are still alive and while at least you are in your sound mind, and it has to be signed by you as the person who is attesting to the will. It has to have my witnesses who will also pen their signatures and also their names appearing there. And this is sometimes where my problems arise, because somebody is made a witness to a will and a beneficiary at the same time.
You can't be a beneficiary.
Exactly.
And sign.
You get what I'm saying. And then we have my instances kuti a will unogoda kunyora waregedza kustate kuti okay, I am saying ndiri kunyora will yangu ndobva ndati okay, my BMW goes to Rumbi when I die.
I receive. That's valid. Kunema ora will.
You see, so when you then, but we don't put the will is silent as to okay, what if Rumbi dies first before Kuda, and then indeed Rumbi dies and then Kuda dies later? Then there is no will. Because the person who was stated as the person who was supposed to benefit
is no longer there.
It's no longer there, and it cannot go kuma dependents ake or kuma successors
because
ake.
It's not stipulated.
It's not stipulated. So these are some of the things that are tricky when it comes to drafting legal documents such as a will by yourself.
So very important that once it's a legal document, get it done. But if you are going to do it yourself, make sure it is in writing. You can write it in paper, you can print it, you must sign it, you must date it, have 2 adults sign who are not beneficiaries. You must be in your full senses and it can have capacity.
Exactly.
To make the will and also understand what you're doing, and also you must make it voluntarily without any pressure from anyone else.
Yes.
Wonderful,
yes.
wonderful,
yes.
wonderful
Yeah.
stuff. Who can legally benefit from a deceased estate?
All right. There is what I can say in plain language, a hierarchy of people who are entitled to benefit. So let's say Kuda have deceased. Then we look at, okay, Kuda had a wife. The wife becomes the surviving spouse. Actopiwas Daraguti surviving spouse. So there is an automatic entitlement to the surviving spouse. And we will go back to my wills. Ndiri married zvandiri ndobva ndanyora hangu yangu, and I decide to scratch my wife out of the will. The will will be declared invalid.
Why is that?
Because it's okay. Let me put it in layman's language. It will amounts to yatingati unjust enrichment. Yokuti, my wife obviously contributed either directly or indirectly to whatever I may be having as part of my assets. My children are my immediate family and my wife, So for whatever reason, if I decide to say, okay, I'm going to transfer all the wealth to my brother and they are not going to be beneficiaries, the law comes in and say, this cannot be, because you are impoverishing the very people who are at law entitled to benefit from the word go.
Absolutely. And also the fact that, unotosungirwa kusabhadhara maintenance. So
exactly.
So there's that kachisungo kanodiwa ipapa.
Yes.
Okay. You bring about something interesting. There was a very controversial case. Yakabuda, I think it was a high court judgment where I forget which honorable judge delivered that judgment, but ultimately allowing a will that disinherited dependents to stand. zvikanzi testamentary that testamentary privilege is absolute. What do you think of that? Very quickly, tisatadzokera munyaya.
All right.
Kuti inini zvandanyora ndozofanira kuitika, so respect my wishes.
Indeed, I think I had sight of that judgment at a certain time. But personally, I think it sets a very tricky precedence if it is to be followed, because it disenfranchise as a society. We are built upon family. Family is the smallest unity of community. And we are what we are because of the family. So the law should also come in to protect family and dependents, spouses. And this is, and when we are saying, as long as Kuda said, and I don't have anything to do with them. You know, it's like, even when you're talking about divorce, if a person says this property, for example, if I say as the husband, if this property I don't want to share it upon divorce with my wife because she didn't put a cent on it, the law makes some inroads to say, but I indirect contribution. Yet the law, especially on property, it says the person on the property, the name on the property is the owner. So if, for example, the house is in my name, it means it's mine.
Yeah.
But maybe my wife contributed 40%. Who knows? Maybe 70%. But the law is saying it's mine. So then I write a will and I scratch my wife out. And then we have this scenario whereby the law will be saying it was Kuda's will, we have to respect it. Definitely the law will no longer be serving its purpose.
Interesting. I know we segued a little bit. Let's come back onto the road, onto this issue.
Sure.
So we were talking about how the assets of a deceased person are distributed. Ukati pane hierarchy, ukati pane surviving spouse.
Pane surviving spouse.
Who comes next?
Then the deceased children, whether they are born in wedlock or out of wedlock. They are entitled. Yes. Because sango ari chengeti vana. So they are entitled to benefit. And then in instances where there are no children, and especially if it's we are talking about the husband being the deceased, we look at the surviving spouse being the wife, the children, right? And then we are good. Now, but there are instances, as I'm saying, where there are no children, or maybe there is no surviving spouse, there are no children. Then we look at the surviving parents. They will then be rubbed into benefit, and then we look at brothers and sisters as well into that. So I'll also be quick to say, if it's Rumbi,
if it's a woman, because I know we're looking at it from a man's perspective. Now, if it's a woman who has died,
the husband still gets his share as the surviving spouse, right? And if there are no children, then the relatives, these other relatives of the wife of the deceased, will then inherit the share which would ordinarily be entitled Kuhana. So what we are saying is, to just clear it or clarify it, we are saying, okay, Ndirumbi, she's gone. Then her husband will be entitled to the matrimonial home and the goods, household goods and assets is the matrimonial home and what have you. Then tapisa jatrukuti, he is entitled. The remainder of the residue from the estate would then automatically go kuma relatives.
Kana pasina vana.
Exactly.
Okay. And then in the instance of so I suppose that is where there is a general law marriage, and it's in my chapter 34, chapter 511, now chapter 515. when it's a customary law situation, we know it's potentially polygamous, and tombo titoita scenario ye kuti pato ripabarika there is more than one wife.
Yeah.
How does the law operate in the customary law realm there?
All right. If it's in the customary law, and then there is more than one wife, I think I'm going to explain some things there. But what will happen is that 1/3 of the estate will go to the wives, and then 2/3 will go to the children in equal shares. And on the 1/3 that the wives will share, the first wife will get 2/3 of the 1/3.
It makes sense. Mathematics, guys. Okay, go backwards. Ndoti vateereri vafambe nesu.
All right.
Saka tiri kuti kana pane madzimai matatu.
Yes.
Tine 3/3 and ndo estate yes.
Yes.
You are saying vakadzi vari vatatu ava ndo vanopiwa 1/3 and
The 1/3 is not very absolute. It's like, okay, if the 3 were staying in their own houses, matrimonial houses, each will retain the house in which they are.
Because they're the surviving spouse.
Exactly.
Okay.
If they were staying under the same roof, they will be entitled to that in equal shares. 1/3.
All right.
Yes. Then the residue from the estate, they are 1/3 of it. So whatever, even if we calculate it in monetary form and say, tapedza tabvisa dzimba tati mamatrimonial home habatwe, we look at, okay, so tachicalculate mama assets esari ukwai, and it's the mota,
my bank accounts,
my shares, my companies, and what have you, and we are coming to a total of 100,000 to give us an example. We then say 1/3 is going to be shared amongst the wives.
Vari 3.
And
the pau 3 waho gets
2/3. The
lion's share. Okay. And then kuvana oku, it's in equal shares of the remaining 2/3.
Yes.
Okay, wonderful.
Yes.
Why the deference to the older wife?
I think what we may have, we may be heading towards seeing some changes especially with the coming in of the new Marriage Act, which is heavily bringing these marriages to parity. I think we may have some inroads being made in the near future. But remember, we are saying kuti, this is being done in terms of our customary law. So customary law, ndoza yanga yagara chitongo dictator. Kuti vamwe ava vakakanganisirawo saka vakatoya panechi
pamba
pavo. Saka ivo semukuru ukaenda kuchishona, even kunano kumachief and what have you, in our culture, you realize that even when a man who is in a polygamous marriage, we will build a house that is a bit different for the first wife. They will give a different level of reverence to the first wife and say, these ones, the ones who are it's okay, but they treat the first wife differently. So I wanted to bring in this scenario, which is confusing and very practical. So Kuda is married in terms of general law, right?
Yeah.
And then proceeds kunorora another wife. Customary.
Onobhadhara
asindine certificate huko yandinayo. Then I have an unregistered customary law union yangu, hati register mtemo wako tinofanira kuregistrwa, but hati register topatagara nayo. Then indeed I get to die. Will that second wife benefit anything in my estate? The answer is in the negative. She cannot.
She cannot because she's not the surviving spouse.
Yes, but where the trick is, people sometimes don't go through my divorce. My wife, Kumba, I don't get to go through the divorce process.
But you are estranged.
pamwe my wife abva ato nechirungu chakazouya ichi aenda kuuk, the marriage certificate is there. Ini ndobva ndanoroora somebody pachivanhu, ndiye muroora akuzikanwa kwaMasiyenyama, ndiye anotoita zvese, ndiye aripo for 20 good years. Then I die. Some come in and say it's not fair to say this young wife cannot benefit anything from my estate. But that's the law. Then the reverse is a bit different, whereby I am married under customary law for starters. And then I proceed to marry another wife and wed with her in terms of the general law.
It now means I can't do that. I can't do that either because I'm already married. Are you married? Yes, I have a customer reunion. I
said, but people don't disclose that.
Hey,
people don't disclose that. Tatungenda kwa mdzviti na mainini vatachata. So we have avamai guru, but avana kuchatiwa nawo asi varipo. Then I die.
Wow. And I like how practical you are getting. This was kuitika.
And the third scenario, Rumbi, that we see happening. Ndekuti my mother vanenge vakarorana namudara wangu. They stay together. They build mansions, houses, they buy properties and what have you. But havana muchato. Ndobva varambana chivanhu chedu chinoti anopiwa gupuro nemidziyo yemukadzi. Midziyo yemukadzi ndezvemukitchen. That's it. It's done. Then she goes. My dad then gets a younger wife.
A younger model.
Yes. But this person is coming. Ndobva vagara vese. Let's say havana futi kuchata. But vagara vese. But she is coming and everything is there. It's a very big estate that is there. Then my dad died. Normally these are practical cases that we see, because tinozonana kuda manje wakuya kuti mudhara wangu akazoshaya, but everything zvakatengwa vaina mai vangu. Mai nino wakazouya prazi rekwakati ratengwa, imba yekubhurudhu yatengwa, chichi mai vangu ndo vaitobikira mabhiridha vaidai. But at the time of separation, nothing happened. You see how tricky these things are. Can my mother be considered as a surviving spouse? Can, even if she is not declared a surviving spouse, can she benefit from the estate?
From the estate, I think it's tricky. From the estate, she can't.
She can't.
Yeah,
that's practical. She can't.
Yeah, maybe as a, if at the time they separated, they were claim as a universal
tacit universal partnership.
Yes, maybe that could have worked.
That could have worked. So these are some of the things, because problem iripo ndeyekuti vanhu vanofananidza distribution yema assets upon
divorce and
divorce.
So tell us some of the quick differences there. Kuti upon divorce versus upon death. What are some of the key things our listeners should remember?
The most important thing is that upon death of a person, say of the husband, the law clearly states how the whole estate, how all the properties will be shared. It's stated in terms of the law. The law will not come in to ask you, Kuti, you are the surviving spouse, but what did you contribute towards it? No, the entitlement is as at law. What the law says goes. But when you are talking about divorce, at divorce, you have to prove your contribution. To say, I contributed either directly or indirectly. So I'm entitled to a share or a percentage. Then the other thing that can happen upon divorce is, imemi as adults, divorce, you can opt to say, okay, we are now giving this property and this property and this property to our kids. You can do that. So you can distribute your assets as you wish, because you are still alive, you are still there. at divorce. But when we are talking about a person afa Javarana, that's why in the upper example yokuti somebody have contributed significantly, but they are not part of the registration, their names are not appearing on the registration papers. The law says it's not yours. So upon death, you cannot come and claim it unless you can prove that no. Before we even talk about this estate, the estate is liable to pay me. Because I contributed 1, 2, 3, and this is the proof. But if you don't do that, then my liabilities estate happens now. Upon distribution of the estate, then you cannot come and say I have a valid claim because it will not work.
Anzi, it can't. You are really riling up a lot of our listeners and lots of questions coming up. This one says, Kuda, what if I elect grandchildren in my will at the expense of my children? And then they put in brackets, me being the surviving spouse.
I didn't really get it.
Anzi, what if I elect, all right, Anzi, surviving spouse, oita o will yake, oba aisa grandchildren, vana vevana, not vana vake. Is that enforceable in terms of validity? Will yakadaro ino pasi square?
Ino pasa as long as wako wana wasiri minors.
Oh, so if they're majors, it doesn't matter.
It can pass.
Okay.
Yes.
All right. Interesting. Zvinongoita. Oh, it only becomes a challenge if they're minors, but then minors,
yes.
I don't imagine that minors will have children at that stage. They shouldn't. Patrick says, Anzi, good evening, my Zoe. And he says, thank you for bringing up this topic. I need to ask, why would I be forced to put my wife in a will if I don't want it to inherit Nshangu? Obvious, mun aninge ainema reasons. Okay. So in other words, we're saying the state dictates how one should distribute his or her wealth. Secondly, because state inopindirawo here pakugowewa kwezvinhu zvakaita setsvimbo zvihari nezvimwe zvechivanhu since iri property yemunhu as well, or vanongopindira pane zvine mari mukati chete. Interesting question. What's your take?
All right, I'll answer the second one first. If you have got your $10, you are very much eligible to write a will. What is required is just an amount of $10, right? So it's not about you owning big things that you then say. So you can write a will, distribute a chimbo zako ne machirako, anything that you own which is of and an asset,
even if it's sentimental value versus bank book value.
Exactly.
That's what value see on how you deem it. So the sentimental value and real book value.
Indeed.
All right. And then the other part of the question where he says, say, for example, I had my reasons for leaving my wife out of my will. Why should I be forced?
The law is there to protect them. And we are saying there are dangers associated with you not having issues with your wife and you don't resolve them. And you decide to punish her in death,
Last hit. You can't come back and hit me.
Exactly. Resolve your issue. You are still there. So at the end of the day, what we are saying is that at least she is entitled to something. The moment she challenges,
then it becomes
a problem. If she comes up and challenges, we will have issues, and the issues of challenging of these wills, challenging of the appointments of executors and what have you, is actually a boiling thing currently in Zimbabwe.
Let me hold you there and let's take a call. I can see my lines flashing. Hello, good evening. You are through to the Capitalk Forum.
Hi, my Zoe.
Hi, how are you doing?
I'm good, thank you. My name is Augustina from Glenlawn.
Hi, Soko.
My Zoe, I was listening to your program. At first, the lawyer said, "Apana mwana wemusangu."
Ndizozo.
You're right. So, my question then comes and say, "Toti Letiti inini, I get married to my husband. Ndine mwana wangu inini. Wandakaita kumashuroko. And then my husband has mwana wake wakaita kumashure. So vataroorana. Then one of us dies. What happens?
Okay, wonderful question, Soko. I could have come in and answered that one. Anzi Ganari blended family.
Yeah.
She no famba say.
Yeah.
Okay. We've lost her. I wanted to ask her, and I think this will help also in answering the question. Did you go through the adoption process? Pamagaita come together.
Together, exactly.
If you have not adopted them, okay, but anyway, let me not answer.
Obviously, it poses some challenges. But one thing that is automatic is that your own children, even those whom you came with into the marriage, will benefit from your estate yourself. Your husband's children, it's automatic. They will benefit in equal shares with the children of the current marriage.
So in the situation that Sokostina describes there, can a person now will atorima one sakanditi?
Yeah, it becomes a problem. Can a person now will, and apparently the adoption process that we are also talking about, because what we are saying is probably her question was coming to say, it's me, ndine wana wangu vandakauya now into the marriage that I have. Then, all right, it's my wife who brought her children, and then we become blended. Indine wangu, according to
and
her.
You don't have any children together.
Maybe we have or we don't. But the challenge, her challenge probably is on when I die, will my wife's children inherit from my estate? Because their mother is still there.
True. And how do you answer that for Sokostina?
These are some of the things that
it's
complex and will be contested big time in courts of law. But
strictly speaking, if there's no will and you don't specify that you want these children catered
to
for,
benefit,
they are not entitled to benefit.
They are not entitled.
Saka kana mafunga zvekuti mukuda kublenda maybe adoption vobvangoita vana venyu vese and then there are no issues going forward.
Sure.
Anditika. Then this one says, hi Rumbi, good evening. I would like to ask kuti pane age limit here yevana vanenge vasiwa nemufi o hapana, and chero mwana asingazivikane as long as birth certificate rake rine zita rababa vake anomuwana mugowe wake semwana.
Okay, so the
Dimaima tipa messaging.
Okay,
Thanks,
thank you. That's an important question. So the issue is the process of estate registration. It's a process. It's not an event. It's not like the surviving spouse anongwenda kwa master akabata death certificate or death notice yake, and then things are distributed. No, they are what are called edict meetings, which will be held, and on those meetings, relatives are invited. And these estates are not advertised in my newspaper. The reason for that is to also reach out. Sometimes not only it covers a lot of things, it includes maybe wanenga my debtors, my creditors to come forth and what have you. But it also includes the issue openness to say this estate is being registered. And if there is a child, asinga zikanwe, it can simply come. So there is no age limit. The only issue is the way a minor is treated is different from the way
a major
is treated. That's where the difference is.
My chitima also comes in and says, Anzi baba avo vanoti havadi kuisa mudzimai wavo pahwill one problem isina kumira mushe nekuti dai paine chikonzero chinobatika ko garai maramba zviri pamutemo anzi hamumiriri kufa musiya mudzimai ari kunze kwepfuma yamashanda muri mose. Please gadzisai nyaya dzenyu muri vapenyu kwete kuomesera mudzimai kudaro. Comments?
I think those are valid sentiments. I think it resonates very well. Solve your issues while at least you are there. And as lawyers, we actually encourage people to say, ita estate planning yako uchiri mupenyu usamirire kuzorongerwa nemutemo wafa. Plan your estate or at least you are still alive. We have a will. If you can't have a will, register your property, register a family trust, you have your properties sorted before you go, and make sure you do it legally so that when you go, it will not have any disputes. So people should
would you generally say, you know, and I don't want this to be a discouraging factor, or I'm not saying you tie this process over the other. She says it's best solved Nikuita will and the trust. Very good point. Wills are challenged quite often. Would you say that what percentage would you say of wills that are challenged are successfully challenged? And with that, what should people do to make it foolproof?
Yeah, the percentage is very high, actually, according to, maybe it's because of why those are usually the issues which you ultimately get into the lawyer's domain, where there are contestations and what have you. But it's quite problematic, the issue of wills and what have you. They are challenged a lot. But family trusts, they are good, but the administration thereof is quite a problem in Zimbabwe. People think I have registered my family trust, I have my trust document, then that's it. But they don't then get to transfer the properties into the name of the trust. That's one. Number two, we also have had cases where the High Court tried to make some inroads into trust to say they are disenfranchising somebody who should because somebody registers a family trust without the knowledge of the spouse, register all the properties
in a trust
hey.
Without your knowledge,
without the knowledge of the spouse.
Wow.
And
let me come in the quick question. This one I think is a relevant one. It's a bit long, but let's see if you can answer it really quickly.
Okay.
This one is from Patience, who says, I have a question. Sekuru vakashaya vanine vakadzi too. Barika sekuru vakashaya 2009. Gogo vakuru vakashaya 2019. Pakasara gogo vadiki vapenyu varipo. Chakutonetsa hanzi takutonetsa muroora vagogo vakuru vakuti imba ngaitengeswe vari kuda mashares avamwene vavo. Handichadi zvekugara pano apo gogo vadiki varipo imba i1 panotongwa sei? Muroora anogona kutengesa imba here spouse ichiripo? I think that's the heart of her question.
No, kwanisi, it will be unlawful. Actually, chaasina kutaura ipapo ndechekuti pakafa sekuru, pakafa wahosi, zvikurati estate haina kuitwa. So I will presume the property is still in the name of the deceased. What they should do is to go and register that estate, and then it will be determined as who can lawfully benefit. And definitely we have spoken about it. There is a surviving spouse. The surviving spouse is the one who will return the property. The law is clear on that.
Wonderful. Now the lines are going crazy. We have to do a part 2 of this one. We do. Akune Panapa, and we've been challenged by today's program. This is Gogo coming in. Gogo Chanzi, please next time, Mozo Tudzo, how to register family trust. So I guess we can part 2 this. There's a lot of issues on how much is it to register an estate, all the nitty gritties. So tune in next week, part 2 coming your way. Could I your parting shot before we let you go?
Thank you, Rumbi. I think Zimbabweans, let's just make sure we take the legal route. Estate registration process is part and parcel of protection of assets. These assets needs to be protected. Go and have them registered. Do it legally. Vanhu musaramwa madzimai uko ndo anowanzo kuramwa kuti ndakusiyana nazvo ngazvidyiwe nehama dzake. Don't do that. Do the legal process. It will help you at the end.
I like that. Kuda, thank you so much. Kuda is our resident guest. Kudakwashe Masiyenyama, top lawyer, this one. Saka Chinofara kana mutuya kuchirongwa. Thank you so much, Kuda. Looking forward to delving deeper into the unresolved things we didn't discuss on deceased estates, as well as going deeper into some of the good ways to estate plan.
Thank you so much and good evening.
Right, so make a date with us next week, same time, as we get into legal matters with Masiyenyama in our Capitalk Forum. Today, very, very great session on deceased estates. So lots of important information for you to hold dear. Now the time is 7 o'clock. It's time for the news.